He did everything his financial advisor told him to do. He set up an asset protection trust. He moved a significant portion of his savings into it. And 2 years later, a judge ruled that none of it mattered. The money was fair game anyway. Now, how does that happen? The trust wasn't fake. It wasn't poorly written. The lawyer who drafted it was completely legitimate. So what went wrong? Let's understand it through the story of Bob. Bob was 63 and owned a small chain of 3 auto repair shops he'd built over 30 years. He was planning to retire in a few years and hand the business off to his son. Like a lot of small business owners, Bob had done reasonably well for himself. Between the business, some rental property, and his retirement savings, his net worth sat around $1.4 million. And also, like a lot of business owners, he worried constantly about lawsuits, a customer slipping in the shop, a mechanic making a costly mistake, anything that could put 3 decades of work at risk overnight. Then it happened. A customer's car caught fire shortly after a repair at one of Bob's shops. Nobody was hurt, thankfully, but the customer's attorney sent a letter putting Bob on notice that a lawsuit was likely, citing property damage and possible negligence. Can you imagine getting that letter? Bob panicked, and honestly, who wouldn't? He called a lawyer he'd seen advertised online who specialized in asset protection trusts, and within about 2 weeks, a Nevada asset protection trust was drafted and funded with roughly $600,000 of his savings. To Bob, this felt like exactly the right move. He'd heard these trusts could shield assets from creditors and lawsuits, and he assumed that acting quickly before the lawsuit was formally filed made him safe. Seems logical, right? Move the money fast, before things get worse. Except that assumption is exactly where the story goes sideways. The lawsuit was filed a few months later, and during discovery, the customer's attorney found a timeline. A demand letter followed just 2 weeks later by a $600,000 transfer into a self-settled trust designed specifically to place assets out of creditors' reach. That timeline became the entire case. The attorney didn't even need to prove the trust itself was invalid. They only needed to show that Bob transferred the money after he already knew a claim was likely, which is close to the textbook definition of what courts call a fraudulent transfer. Bob's attorney argued the trust was properly drafted and legally recognized under Nevada law, and the judge actually agreed the paperwork was fine. But the judge also ruled that because the transfer happened after a known specific claim existed, an exception applied for existing creditors, meaning the trust's protection simply didn't cover this particular debt. So here's a rule almost nobody explains clearly before someone finds themselves in Bob's exact position. Roughly 20 states allow what's called a Domestic Asset Protection Trust, or DAPT, a trust where you can transfer in assets, still remain a discretionary beneficiary, and after a waiting period, those assets become largely shielded from future creditors. But here's the catch, and I really want you to sit with this. Every state that allows these trusts sets a waiting period, sometimes called a seasoning period, before the protection fully applies. In Nevada, it's 2 years. In Delaware, it's 4 years. In Ohio, it's as short as 18 months. During that entire window, a creditor who already existed at the time of the transfer can still challenge it and potentially reach the assets anyway. And here's the part that trips people up more than anything else. That waiting period only protects you against creditors who didn't exist yet when you funded the trust. If a claim, or even a serious threat of one, already exists, like Bob's demand letter, moving assets into the trust afterward doesn't start a clean clock. Courts will look directly at that timing every single time. Why does this catch so many people off guard? Honestly, because most of the marketing around these trusts focuses on the fact that they exist and that they work, without ever emphasizing the one condition that actually determines whether they hold up. The assets need to go in before any specific threat appears on the horizon, not after. And there's even a bigger wrinkle that applies no matter which state's trust you use. Under federal bankruptcy law, specifically Section 528 of the Bankruptcy Code, a bankruptcy trustee can claw back transfers into a self-settled trust made within 10 years of a bankruptcy filing, if the transfer was made with intent to hinder, delay, or defraud creditors. 10 years. Let that sink in for a second, because that's far longer than any state's own waiting period. So even a trust that fully seasoned under Nevada's 2-year rule could still be vulnerable if the person later ends up in federal bankruptcy court within that 10-year window. One more detail that genuinely surprises people. Setting up a trust in Nevada or Delaware doesn't automatically mean your home state will honor it. Several states, including Florida, don't recognize self-settled asset protection trusts for their own residents at all, no matter which state the trust was formed in. It's a real legal gray area, and it depends heavily on where you actually live. So, if these trusts can still be a legitimate, useful tool, what does doing this correctly actually look like? Let me walk you through it. First, and this is the big one, these trusts only work as proactive planning, not reactive damage control. The right time to fund one is years before any lawsuit, claim, or foreseeable liability exists, not after a demand letter shows up in your mailbox. If you're already facing a known claim, it's generally too late for a DAPT to help with that specific claim. Second, keep clear financial records showing you were solvent and had no known claims against you at the time you funded the trust. This documentation becomes absolutely critical if the transfer is ever challenged years down the road. Third, remember that a trust is not a substitute for adequate liability insurance. Most asset protection attorneys will tell you to use a trust alongside strong general liability and umbrella coverage, not instead of it. Insurance absorbs claims, so the trust never even has to be tested in court in the first place. Fourth, before setting one up, confirm with an attorney whether your home state actually recognizes out-of-state asset protection trusts at all. If you live in a state that doesn't, a trust formed elsewhere might not protect you the way you would expect, no matter how well it's drafted. And here's the mistake I want you to avoid above everything else. Never treat one of these trusts as an emergency response to a lawsuit that's already looming. That is exactly the pattern courts are trained to look for, and it's usually what turns a legitimate planning tool into a losing legal argument. So what happened to Bob? The SF court ultimately allowed the customer's claim to reach a significant portion of the trust, essentially treating the transfer as if it had never fully happened for that specific lawsuit. The legal fees alone, just fighting the case, cost him tens of thousands of dollars on top of what he ultimately had to pay out. Bob didn't do anything illegal here, and his attorney hadn't lied to him about the trust being real or properly formed. The mistake was entirely about sequence, trying to build a shield after the fight had already started, instead of years before it. So let's bring it all together. The key lesson: asset protection trusts only work when they're funded well before any specific threat exists. Moving money after a claim appears usually accomplishes the exact opposite of what you intended. The biggest mistake people make is treating these trusts as an emergency response tool instead of long-term proactive planning done years in advance. Here's your action checklist. Fund any asset protection trust years before you anticipate needing it, never after a claim or threat exists. Keep documentation proving you were solvent at the time of the transfer. Pair the trust with strong liability and umbrella insurance rather than relying on it alone. And confirm your home state actually recognizes out-of-state trusts before you assume you're protected. So, if you're a business owner or property holder thinking about asset protection, the single most important question to ask yourself isn't which state has the best trust laws. It's, am I doing this early enough for it to actually work? Because as Bob found out, being 2 weeks too late can end up costing just as much as never planning at all.